Good afternoon and welcome to the Institute for the Fiduciary Standard Panel on the incoming, recently delivered to the OMB Department of Labor Fiduciary / Conflict of Interest Rule. Today we have two panelists who have extraordinary experience and perspectives on what the rule might be, or what the rule should be, or what the rule should address. First, we'll start off with Phyllis Borzi, who is the Assistant Secretary for EPSA from 2009 to 2017. And then following Phyllis, we'll have Chris Tobe, who is the investment manager for the Racial Justice Impact Fund, and Mr. Tobe also is involved in a number of legal actions regarding retirement funds and representing investors in those funds. So. And then I will follow Chris with some comments myself. But to start off, Phyllis will provide sort of an overview of how she views the environment that this rule is facing today, and then Chris will follow by drilling down on the situation regarding the insurance industry and retirement accounts, and then I will follow and discuss a little bit the claim by those who oppose the rule that Reg BI is there to do what the rule claims it will do, and such so that the rule is not needed. So with that short introduction, I'll hand the mic over to Phyllis. I should say afterwards, then of course we will open up for questions from those attending. So Phyllis, the mic and the floor is yours.
Thanks, Knut. Well, first let me apologize to the familiar faces and names I see out there on my little screen, because I know you've heard a lot of what I have to say before, but it bears repeating because there are always new reporters and new, certainly new congressional staff, new people in the field. And there are a few sort of basic ideas or basic factors that describe the problem facing consumers who are harmed by conflicted investment advice. And I just want to lay them out in the beginning and also talk a little bit about why the DOL's role is important in this debate. So let me start where I always start, by saying everyone, including all of us who are experts, so-called, in this field, need financial advice. But many, many ordinary Americans are reluctant to seek it because they don't know who to trust. From the very beginning, the goal of the Department of Labor was to create this climate of trust so that more individuals will seek out the kind of professional advice they need. And they sought to do it by establishing a legal baseline for those who hold themselves out as trusted advisors, not salespeople. The overwhelming weight of independent data shows that investors can't tell the difference between when people hold themselves out as expert, between people who actually are giving them trusted advice and people who are just selling products in which they have a personal financial interest. And so investors have to think hard about this, and it's very hard to distinguish. The data also show that disclosure alone is insufficient, and certainly those of you who have been reporting in this area for many years understand this. Any kind of investor confusion or lack of understanding cannot be solved simply by disclosure alone. God knows we went through that. We went down that rabbit hole in the first proposal that we had in from the Department of Labor in 2010, where we tried to clearly distinguish between investment advisors subject to a fiduciary standard and salespeople. We were roundly criticized by industry because we took that route, because they said you can't distinguish this way. And then, of course, the second proposal that we issued in 2015, I guess it was, when we said, fine, okay, we'll just do a baseline that applies to everybody. And that wasn't acceptable to the industry as well. But anyway, it's clear that at the root of this, that confusion is a symptom, not the problem. The problem is the current financial incentives that are embedded in certain business models for those that provide advice are not aligned. These financial incentives are not aligned with the interest of the recipients of the advice. The various compensation arrangements that are built into many of the industry business products create strong financial investors for advisors. Of course, only some of them follow this instinct, but for advisors to steal clients to particular products or investment strategies that actually are just more beneficial for the advisors. Some of you might remember my former Deputy Assistant Secretary, Michael Davis. Michael used to remind us all the time when we were working on this project that from a business point of view, we had to remember that people do what you pay them to do. And so if the financial incentives between the person giving advice and the person receiving the advice are not aligned, you're always going to have a problem. Despite the fact that all of these folks, when they market their services, tell people that they are working in their best interest. Now, I know you've all been hearing, those of you who've been following this, have been hearing the industry argument that because the SEC has issued Reg BI, which, by the way, has been in effect for more than 3 years, and the NAIC has published this model legislation on suitability. They don't even pretend that they're looking at a fiduciary standard. They call it suitability for investment advice. So the industry is saying because the SEC and the NAIC have done something in this space, there's no real reason for the department to act. And as a matter of fact, the industry and its congressional allies are actually claiming that it would be harmful to investors were DOL to issue a new rule. Well, in the words of President Joe Biden, that's malarkey. I could use a stronger word, but I take my cue from President Biden. Contrary to what you've heard from the industry lobbyists and their supporters, not only is there a role for the Department of Labor, but it's essential that they step in to fill the gaps, to protect all of the investors in the retirement marketplace. Unfortunately, their previous attempt to address these legal standards that should really guide the provision of investment advice was based on a now quite outdated 1975 regulatory effort that established a 5-part test for defining fiduciary conduct. Now, I'm not going to go through the details of that, but if you want to ask me questions after that, I'm happy to answer it. Interestingly, though, I'll make one observation. In the many courts that looked at the department's final rule that was issued in 2015 or 16, I forget actually even, the only court that didn't make an affirmative finding that the 2015 regulation was actually closer to the statutory language was the Fifth Circuit. All the other courts concluded that the 75 test was not nearly as based in the statutory language as the DOL regulation. So anyway, why is this important? Why is a fiduciary standard important? Well, the fiduciary standard under ERISA has been described by experts as establishing the highest duty of care in our legal system. And as I said before, many of the people who hold themselves out as experts and advisors in this area, are held only to a much lower suitability standard. The exception to that, of course, is investment advisors, RIAs, because as opposed to brokers, because the RIAs are subject to a type of fiduciary standard under the securities laws. So since 2009, the Department of Labor has been trying to find that right balance to revise that 75 regulation and bring it, update it, modernize it, if you will, to recognize the realities of the current marketplace. And not surprisingly, they've been opposed at every turn by the financial services industry, and most particularly the insurance industry. They've resisted all sorts of change. But the dirty little secret, the factual thing, in fact, is that there isn't any one agency or entity that can regulate the entire retirement plan marketplace. The SEC and the state securities regulators are limited to regulating securities. Now, that's a big category of regulation, but it's still limited to securities. And that includes not just mutual funds, but a couple of categories of insurance products, primarily the ones that compose mostly of investment components. Insurance products generally are regulated by the states, and they are subject to the patchwork of regulation and the varying resources available to the states for oversight, supervision, and enforcement. In contrast, sharp contrast to that, the DOL is focused on any and all types of retirement assets that can be sold to or held by individuals or plans in the retirement marketplace. So it doesn't DOL regulates the conduct of the people who advise people and as to where to invest their money and how to structure, and plan sponsors how to structure a plan. DOL regulates any of those products that can be sold to or held in retirement plans. Doesn't matter whether it's a DB plan, a DC plan, an IRA, all of those retirement plan assets, regardless of their category, are regulated by the DOL. You know, when I was at the DOL and I was talking to members of Congress on the Hill about this, I used to carry around in my purse a Venn diagram. Maybe some of you are old enough to remember Venn diagrams when they were taught in class. And I had the DOL with a circle, the SEC with a circle, and then that center of the Venn diagram was where the two jurisdictions overlapped. But there were parts of the world, the non-retirement, fully taxable investment world, that the SEC regulates. The DOL doesn't touch that. The DOL's regulation is limited to tax-favored retirement income products. So even if you believe, and I don't, and my panelists will tell you their views on whether or not they think the SEC or the NAIC regulation are adequate, even if you believe they are, there's still a wide variety of asset classes which can be recommended to plan participants or IRA investors that will not be subject to either NAIC or SEC oversight. And just, I'll give you a couple of examples. Bank products, like collective investment trust, neither state insurance regulation nor the SEC regulates them. Real estate, private equity, various other kinds of hard-to-value assets. And in fact, actually, many of these insurance products that aren't securities regulated by the SEC, like most annuities, that are sold in the states that don't have uniform, strong insurance regulatory structures and enforcement, participants in plans and IRAs are still at risk when they get advice to buy those products. But in the 8 years that I was at the DOL, the issue that concerned us the most about lack of fiduciary standards was advice given in connection with rollovers. So if you think about rollovers in two steps, both the recommendation to take a lump sum distribution from the plan and then where to invest those assets once the rollover has taken place, both of those recommendations involve fiduciary advice. DOL has tried mightily in various types of regulatory guidance, from regs to prohibited transaction exemptions to FAQs, to make that clear. But the industry, of course, continues to fight that, because when you think about assets under management, which is what most financial institutions are focused on, the tsunami of assets that have moved out and are continuing to move out of the tax-favored, ERISA-protected world of plans into the IRA space, which are largely unregulated and don't have that critical component of a fiduciary as an intermediary between the product and the participant making the choice, or the individual making the choice. When you think about that, the lack of consumer protection is pretty acute. Now, over the years, I have to admit, there has been some progress made towards addressing this problem of conflicts, but much, much more needs to be done. So let's think about for a couple minutes, and I'll finish up this way, about the kinds of things we expect the department to include in a new proposal. Now, let me say at the outset, I have no inside information. I don't know anything more than you do about the content of this regulation. However, many of you on this call have reported about the kinds of things that the ERISA leadership has been saying about what they plan to address. So let me just tick them off, and then I'll turn it over to Chris. The first thing we can expect is a redefinition, a reconfiguration of the definition of fiduciary under ERISA 3, Section 321. It will get rid of the 5-part test. There may be some components of the 5-part test that are included, but we'll see a new definition of fiduciary that is, I suspect, more closely aligned with the statutory language than the 75 regulation. The department has said that it's looking back over all the pre-existing prohibited transaction exemptions to see whether anything needs to be changed in that vast number or substantial number of PTEs that are out there. We probably will see a new PTE replacing the one that was issued in the Trump administration, PTE 2020-02, to conform with whatever changes they make in the statutory definition that they're proposing. And I think probably from the insurance industry's point of view, the most important change, or the change they would hate the most, is changes made to PTE, the old PTE that deals with insurance commissions, PTE 84-24. The department has made it pretty clear, I think, in various public forums, that they intend to incorporate the impartial conduct standards that were in the Trump administration's PTE 2020-02 into PTE 8424. Now, what are these impartial conduct standards? They're actually pretty simple. But the reason that 8424 has been so popular with the insurance industry is because it practically has only disclosure standards. It's a very easy standard to make. It's been their go-to exemption since 1984 when it was issued, and continues to be today. But the impartial conduct standards have really 3 parts. First, the best interest standard, and this requires that advisors always act in the best interest of a retirement investor. And this best interest standard is very specific. It incorporates 2 of the statutory fiduciary standards explicitly. the duty of prudence and the duty of loyalty, and requires you as an advisor or as a broker dealer firm to acknowledge fiduciary standard status. The second component is reasonable compensation. Um, I, it always mystified me why the industry was so up in arms about reasonable compensation. Oh my, how could we possibly tell? Well, excuse me, the reasonable compensation standard is derivative from the rule of trust, the common law of trusts. It's been in the Internal Revenue Code for decades and decades and decades, and in ERISA for almost 50 years. So reasonable compensation. And the third component is you're not supposed to make misleading statements regarding investment transactions, compensation conflicts. Now, normally OMB has 90 days to review the DOL proposal, and we'll be meeting with various stakeholders who request a meeting. So the only thing I can say is watch this space. Stay tuned. Thanks.
Thank you, Phyllis. Great overview, great summary. Next, we'll turn to Tobe. Chris.
Hello, everybody. Again, Knut introduced me as playing one of my hats. I work for a woman minority-owned firm in which we do consulting to pensions, and then we also have a fund. But my main thing that's gotten me here today is my main business is I have been a expert for plaintiff cases and 401k ERISA cases in over 80 different cases. So I really see where the rubber meets the road, and all the fiduciary problems I'm finding in all these plans don't even seem to be even addressed anywhere. And I think Phyllis's the way she's pushing is just a start. But one of the things to think about, though, is that of the $600,000 plans in my database of 401k plans, about 6,000 of them are probably subject to litigation. So that's only 1% are subject to litigation. That's the part that I'm really familiar with. That's still 6,000 plans out there. And but again, the other ones need the protection of a broader rule, like Phyllis is talking about. So in the litigation front, what I'm looking at and seeing, again, part of my background is I've been almost 40 years in the investment business. I've worked for banks. I've spent 7 years with Transamerica pricing these annuity products, 7 years as an officer. So I really know how the sausage is made, how these profits are made within insurance companies. And that's what gives me the expertise that I've been involved in. Probably over 50 of these cases have involved insurance products. So I'm very much into that. Most of them have all settled. We settled one this morning for $3 million versus a hospital in Georgia, another hospital in Louisville. We did one way back. We've got trials going on in a number of these all around the country. And what is happening is that there's this excessive fees in these products, well over 200 basis points or 2%. That I'm seeing all over the place in these insurance products. And so in the 401k field, we're making a big deal out of someone overpricing a mutual fund by 10 basis points, 50 basis points when they should have been 40. What we're finding in these annuity products is we're seeing overpricing of 100 basis points, 200 basis points, 10 times the amount that we're seeing in the mutual fund area. So that's, from my perspective, that's why I think there are issues there. And again, also, these fixed annuity products are 100%. You have 100% single entity credit and liquidity risk. I think there's all kinds of fiduciary issues with all of these annuity products because of the single entity credit risk and single entity liquidity risk. So those are the type things that I'm looking at every day. What I see out in the market right now is I see all these insurance salesmen going after $200,000 rollovers, then making themselves a quick $15,000 commission. And then that retiree is stuck with a contract with a single entity, single credit risk that he could lose all his money if the firm ever went under. And he's got this stuck with this annuity with an embedded fee of 200, 300 basis points, 2 to 3% inside of it. So I think the biggest threat to what the annuities industry is doing to retirees is the big damage being done out there today all over the place. And these fiduciary rules are some of the ways to start to get a handle on that and start to reduce these damages that are done to retirees every day, especially in the annuity space. I mean, they're trying to get into the private equity space, and crypto tried to get into 401k as well. again, to me, these assets that are non-security based or non-SEC mutual fund based, all these contract based assets, annuities, private equity, crypto, all are very problematic in their structure. That's just, I call it almost an anti-fiduciary structure. It's designed to hide risk and hide fees. And when you grant these exemptions, which I'm calling get out of jail free cards. Basically, these exemptions allow them to have less transparency when they really if you're going to allow them, need a lot more transparency. So I'm taking a much probably more radical view than Phyllis on this stuff. You has to live in the real regulatory world of DC. This is kind of what I'm seeing as a practitioner out there, how bad these products are, how I would recommend them to members of my family and things, that we've got so many really bad products out there causing lots of damage to retirees. And transparency is just needed. We need a much higher level of transparency if we're going to allow these non-transparent structures into our retirement system. Again, revenue sharing is another issue that I have an problem with. Another way, and then there's conflicted consultants, consultants who get commissions, create a conflict of interest right there. And then we've had many of these plans will use consultants who have been fined by the SEC for overcharging on fees and don't even seem to care. I bring that up in cases a lot, that they've hired a conflicted consultant who has been fined by the SEC for doing this and that, and so on. So those are the type of things that I've been working on while consulting to these cases. But again, these cases are only on the top 1% of plans, the largest 6,000 plans, which is probably over half the assets. But it's where that's where I'm battling the fiduciary, making my fiduciary battles there. But I think the other plans really need the help of the regulators. So that's kind of my basic and I'd love to have questions and discussion on these.
Thank you, Chris. I'm now just going to offer a couple comments about one of the allegations, or maybe assertions by the opponents of this rule. And let's keep in mind that they have not seen this rule, and they've come out galloping against it, something that they have not seen, which of course in and of itself says something. But one of their assertions is that this rule is not needed because Reg BI has been implemented to take care of the issues that this rule is assumed will address. And of course, part of this assertion on its face doesn't make any sense because of what Phyllis pointed out in terms of all the places where the SEC does not cover those products or that will be inside a retirement plan. But nonetheless, it is something that is stated as a reason why we don't need this rule. And I think this is a good time just to, at a high level, recall where we are with Reg BI in terms of knowing how effective it is after 3+ years under enforcement, so to speak. But the best place to begin, I think, is the day that the rule came out. And the day that it came out, Consumer Federation, which probably everybody on this call will recall, came out and said that the rule was too weak. The rule would not achieve its stated objective. And one of the reasons why it was that best interest in and of itself was not defined. And of course, that paper was co-authored by Barb Roper, who is now in the office of the chairman and no longer Consumer Federation. But that, to me, is the beginning of understanding why Reg BI has pretty much failed entirely after 3+ years in achieving what it was set out to achieve. And I think that one way of looking at it from a high level is to highlight the 3 particular events in the development Reg BI that happened last year. And those developments that I highlight are number one, the SEC staff stating in the end of March in 2022 that it was unnecessary and could actually be harmful for registered investment advisors to put the word fiduciary on their form CRS. And that came out in a staff opinion Q&A, I think March 29th, March 30th, and has not been adjusted since then. So there's the first sign of how Reg BI is being interpreted and applied. I think the second sign was the first case brought by the SEC on Reg BI. I think that was in June of last year. And that the bottom line with that case, which was noted by several securities attorneys, I think that case could have been brought against the firm in question under the old suitability rule. So what does that tell you about Reg BI? And I think the third sort of example is in August, the SEC came out with another guidance on the issue of conflicts of interest, and that guidance, in a word, basically did not offer anything new or anything different in terms of clarifying, defining, applying what Reg BI means about conflicts of interest. And so there are three. I think those are three data points that matter. And I think before then, in November 2021, the NASA, the National Association of State Securities Administrators, came out with their paper analyzing the effect in the states of Reg BI, and basically concluded that nothing much had changed, i.e., by and large, the brokerage firms had not changed their practices, had not adjusted to what was supposed to be the higher standard for a broker dealer standard. And so that pretty much I think tells the story in terms of what Reg BI has done so far. Of course, there's still opportunity for change. There's opportunity to take a new direction. There's opportunity to provide different guidance and to provide a different enforcement approach to Reg BI. But so far, I don't think that we have seen that. And so on that point, I will pause or conclude my remarks and open up the floor for questions. Mark.
Yes, a question for Phyllis, because you were you were right in the middle of the regulatory fray for so many years. The DOL proposal went to OMB on Friday, just a couple of weeks ago. It could be at OMB for 90 days. It'll certainly be there for a few weeks, maybe a couple of months. And that's even before the DOL releases to the public the proposal. Then there'll be a comment period, and then they have to review comments and so on. You know the rulemaking process. Has the DOL put itself in a position where a Congressional Review Act resolution could kill this rule in the next Congress, if the next Congress goes Republican and a Republican is elected president?
Well, that's always a possibility. The clock is never your friend in the rulemaking process. It depends on how much the department wants to accommodate the inevitable pleas for extended comment periods. As you might remember, I remember painfully how long it took us to go from the first proposal that we put out and of course I finally found my notes on it. We first put the proposal out in October 2010, and it went from then we withdrew it the next year. It took us till April 2015 to put together a new proposal because we went out of our way to accommodate the hundreds of requests from stakeholders, mostly industry stakeholders, but also I did a lot of congressional briefings. So did the staff, so did both Secretary Solis and Secretary Perez, Secretaries of Labor. The regulatory process can take a long time. It normally takes about 2 years, 18 months to 2 years, from the time the rule is first proposed in the Federal Register to the final proposal. But it expands and contracts based on the public interest. And the department, certainly when the 8 years I was there and worked on this rule, we did bend over backwards to accommodate the public notice and comment on the rule. The CRA is always a possibility. It's always a danger. But to me, when I was the assistant secretary, I wasn't so much concerned about the CRA, as I was about giving the industry adequate time from the time the rule was finalized to what's called the applicability date. That is the date that you have to come into compliance. And you might remember that one of the reasons that we ran into trouble with the CRA is because although it wasn't successful in killing the rule, was because we were determined to give the industry a year to bring itself into compliance. So those are the tensions. You're absolutely right, Mark. There's always a danger lurking about the CRA, the potential for a CRA challenge. But as somebody who was responsible as the head of the agency, I was more concerned in making the rule workable and reasonable in terms of compliance for the industry, although it was always in the back of my mind.
Thank you.
Can I say one more thing that I forgot to say when I was giving my initial talk? One of the things that's so interesting about this argument that the DOL shouldn't do anything is there seems to be an implicit assumption that somehow the DOL rule is going to be conflicting with what the SEC has done. I would, if I had a family farm, I'd bet it on the fact that the DOL rule will be designed to be supplemental. So the kinds of things that Knut talked about in terms of the weaknesses and ambiguities in the SEC Reg BI, I think what you're going to find, because you certainly have seen that in the things that the DOL has put out since the SEC put out its Reg BI package, is that the DOL rule will be supplemental. So if you assume, for the sake of argument, and of course Knut pointed out some of the reasons this assumption is not necessarily valid, but if you assume that because people had to comply, people subject to Reg BI had to comply by June of 2020, if you assume people are in compliance, then it isn't such a big deal to have to do supplemental work to refine that compliance with Reg BI. But if they're not in compliance after 3 years with Reg BI, then yeah, it's going to be a harder lift for them to get to wherever the DOL. But think about it as a supplemental regulatory action, not a displacing regulatory action. Because I think when you read it, that's what you're going to see.
Phyllis, I have a question, a follow-up question on that.
Sure.
I mean, if we're assuming, I mean, as you and Knut have sort of said, if Reg BI is pretty weak and hasn't done a whole lot, then what will the benefit be of the DOL doing anything if it's essentially the same thing?
Well, the DOL has a different statutory and enforcement set of functions. And so I think the DOL enforcement actions can help if coordinated with the SEC, what the SEC is doing. I think in some respects, you know, the regulated community, I hate that term, the regulated community, but my career staff used to use it all the time, so I fell into the habit of using it. The regulated community never want, as much as they talk about agency coordination, they don't really want that. They don't want agencies to work together because of the power of the collective efforts. For probably a good 15, if not 20 years, the DOL, EPSA, has had a memorandum of understanding with the SEC enforcement people to work together on enforcement projects. And behind the scenes, there certainly was a lot of that going on in the 8 years that I was at the DOL. This is an area in which I think the collective enforcement efforts of the two agencies can actually be helpful to the SEC in terms of strengthening its own enforcement activities, because the agencies can, and in the past have, worked together on this stuff. So, but your point is well taken.
Phyllis,
Well, it sounds like, oh,
no,
I'm sorry.
Greg, go ahead. Greg, go ahead.
Because we're talking about a fiduciary rule, and it sounds like it, based on that explanation, it wouldn't really be a fiduciary rule. It would just sort of be another best interest rule. Again, we
No,
haven't
because
seen
it's
what
going to, well, according to their public statements, they're going to refine the definition of fiduciary. See, the thing is, DOL doesn't regulate products, it regulates conduct. And in order to regulate conduct, you have to be a fiduciary. So the purpose of the prior rulemaking at the DOL has been not to raise the substantive standards applicable to fiduciaries so much as to expand the class of people who are subject to the basic duties of prudence and loyalty and the other fiduciary standards. So when the DOL regulates by changing, before they didn't define, they didn't affirmatively change the 5-part test in a direct way. They didn't they didn't necessarily revise the definition of fiduciary. But this time they are proposing to do that. Before, what they did was try to approach it from a minor tinkering with the existing regulatory 5-part test. I think now they've probably decided, based on the activities in the litigation and what they see in the marketplace. Again, I don't have any inside information. I'm just telling you what I think based on the discussions that were had during the 8 years I was there. I think that by going back to the drawing board and reconstructing who is a fiduciary under the statute, they will have broader enforcement powers. And that's because the only people they can regulate are fiduciaries and to some extent the service providers the fiduciaries hire.
Mark?
I have two more quick questions. This was brought up during the Obama era fiduciary rule, but let me ask it again. To what extent are investment advisors likely to have to change the way they give retirement advice under this next iteration of the fiduciary rule? It's called a fiduciary rule. Investment advisors are already fiduciaries. Does that mean they've got a free pass? This isn't going to affect them, or should they be paying attention? And if so, in what way?
I think, again, I'm sort of at a disadvantage. We all are, because we don't know this exactly what they're proposing. But I can certainly speak to the rules that were issued during the period I was there in the Obama administration. There was no free ride for anybody. The the investment advisors are subject to a type of fiduciary duty under the securities laws. That fiduciary duty has many, many elements in common with the ERISA fiduciary duty that's in the statute, but not entirely. So, for instance, one area that when I talk to investment advisors, I would tell them that they needed to be careful, because one area that they needed to think about upping their game was in the disclosure and record keeping side. That the ERISA fiduciary standards required, and the proposal that the regulation that the DOL issued, the PTE, the contract prohibited transaction, would require investment advisors to make some changes in the way they operated. And I suspect we're going to see the same thing in this. So it's not a free ride for investment advisors, but since some of the basic concepts that underlie the ERISA fiduciary standards, like the basic concepts that the Investment Advisors Act and the courts have imposed on investment advisors under the securities laws, are quite similar and very compatible. So they have a harder lift, they have an easier lift to meet whatever the standards are than the broker dealers, many of whom, and I've said this before when I was at the department, a fiduciary status under ERISA is a facts and circumstances test. And so even though the broker dealers would categorically come into my office and elsewhere and insist that this was some brand new duty they had under ERISA that we were imposing through our regulatory guidance. When you look at the facts and circumstances of the way they advised people, the kinds of recommendations they gave, there were some of them, not all, but there were some of them that met the existing 5-part test. So they would have been fiduciaries under ERISA, even though they categorically believed that they were never subject to ERISA's fiduciary rules, and this was some brand new thing that they were subject to. I hope that answers your questions. And
Yes,
Greg, I'm
thank
sorry,
you.
I hope I answered your question too.
Greg, did you have a follow-up?
Yes. You just have to remind me what the most problematic part of the current 5-part test is. It's something like ongoing. There's an ongoing relationship has to be one of them.
Yeah, there are a couple of them. The 5-part test is, the first one is you may render advice about securities, other property, or make recommendations about investing in, purchasing, selling securities or other kinds of assets. But the regular basis prong was one of the ones that was always difficult for the department to deal with. And it came up primarily in two contexts. The first is when the recommendation is to purchase an annuity. That's why I was really interested in what Chris was saying about the product, the content of the products that are on the market, because they aren't transparent. But the department would have difficulty in establishing that the broker that gave the insurance broker that gave the advice to purchase the annuity was a fiduciary because they weren't giving, they would argue that the broker would argue that they weren't giving advice on a regular basis. This was a one-time decision to purchase an annuity. The second area where this was difficult was the rollover context, where they would make the same argument. They would not separate the two parts of it, the recommendation to take the money out as a lump sum. And even if they, and the second part where they recommended where to put it, but they would argue it was just a one-time recommendation, so therefore they didn't meet the regular basis. The other prong that was difficult, actually there were sort of two of them, but the other prong that was different was that the recommendation the advice had to be pursuant to a mutual agreement. And there, the problem was they all had disclaimers. I remember when we first started working on this rule in 2009, even though we didn't issue it to 2010, I'm addicted to the Sunday morning talk shows. And so I'd be sitting there and I'd see ads for all these financial services companies. And if you looked in the teeny little print on the ad, what you would say is, this is not intended to be, and they'd mimic the words of the 5-part test to say, you can't rely on this, there's no mutual agreement, this isn't the primary basis for your investment decision. So the primary basis and the mutual agreement, those were the pieces of the test that were most problematic for the department.
Yeah, thank you for answering that.
Any other, Mark?
I have one last one, and that has to do with the migration of BDs to the investment advisor sector. If the DOL fiduciary rule is promulgated and finalized and it sticks, is that going to be one more reason for brokers to say we might as well become RIAs anyway, because fiduciary is just that much more prominent in the market? Or is there going to be more gray area than that?
Well, good question. I mean, speaking for myself, I've always thought the two most difficult policy issues to deal with in structuring a rule include, or certainly were, how to deal with the dual registrants. Because there, while you're allowed to wear two hats, the customer has no idea what hat you're wearing. And so if you have a fiduciary duty as an investment advisor, but you only have the suitability standard as a broker, and you're a dual registrant, it's impossible for the customer to tell the difference. And what I see, and you guys report on the market more than you know more about the market trends than I do. I just read your stories. And it does seem to me that there's this movement towards establishing investment advisor components within the broker-dealer or associated with the broker-dealer. So what I see as just an ordinary minister without portfolio consumer of this information is a more difficult road for consumers because there are more dual registrants. Now, if what you're suggesting, Mark, is that what you see in the marketplace is the abandonment of the broker-dealer model and moving entirely to the IA, I say if it's a fee-only registered investment advisor, I don't know that that's so bad. It's certainly better than the two-hat thing. I think, Chris, did you want to add something there?
Yeah, I think it's more of a problem than a dual register. It's a triple register. So they'll be registered as a broker, RIA, and insurance salesman. So what I'm
you're
afraid
right.
they're going to do is that the RIA, they'll drop the broker part, but then they'll do all the stuff that I don't like them to do under their insurance license, and then still keep the RIA. So I see it's more of it's not dual registered. It's just I think there's more of them are actually triple registered than dual. A lot of them out there are millions of them out there.
And Chris, that reminds me that the second issue that I was very concerned about, and certainly when I was there, I don't know that we addressed adequately, is the question of how to hold the independent broker accountable. If you work for a broker dealer, then the broker dealer can have, in the rule, we required policies and procedures, and then you had to impose them or enforce them with respect to the brokers that worked for you that sold that product. But if you're an independent broker and you sell all of these, that's another reason why the DOL should be involved in regulating here, because it's the conduct of the people making the recommendations that's important. Because if the products you sell span all these categories, and isn't that the way independent brokers operate? They sell, if they have insurance licenses, they can sell insurance. They could sell securities if they're registered to do that. They can sell all sorts of products.
Well, and they can get fees in all kinds of different ways. I mean,
Yeah.
you can get the fee disclosure among the insurance products and even some of the brokerage products. They can get backdoor things for what I'm seeing all the time. So they're doing roles that they're pretending to be a fiduciary, and then through the back door of their securities license and their insurance license, they're being compensated back to pick certain high fee, high risk products. So that's one of my main functions there, is that the system allows that to happen, and it happens quite often.
And I think, Chris, to your point, it wasn't long ago that Commonwealth was boasting about those advisors who had gone fee only in Commonwealth, and they were holding out them as fee only. What they forgot to mention is that most of them also had insurance licenses. So there you go. Talk about
that's good.
Just another of many examples, I think. So, all right, we are at the top of the hour. If there are no more questions, I thank our speakers, thank our reporters, and just remind everybody that we have our next Fiduciary Institute Fiduciary September event tomorrow, and we're going to hear a panel at 3:00 about whether there is too much sales or too much fiduciary in the RIA community. So that's something to look forward to. And but hopefully you'll be able to sleep tonight notwithstanding the excitement, and hope to see you there as well. So on that note, let's call it a day, and I thank you once again for joining us.
Bye, everybody.
Thank you.
Thank
All right.
you.
Thanks,
Phyllis
everyone.
and Chris.
Nice to see you.